The following is paid programming. Opinions expressed are not necessarily those of this radio station, its advertisers, or sponsors. Welcome to All About Love, a program for couples, would-be couples, or anyone with an interest in having amazingly successful relationships at home and at work. With your host, Wendy Pegan, relationship expert, mediator, and founder of the Creative Relationship Center, and sponsored by Lancaster Medical. If you would like to participate on today's program, call now, 803-1520. That's 803-1520.
Good morning and welcome to All About Love, where every Sunday from 11 to 12 we discuss relationships from couples, family, divorce, and everything in between. Hi, I'm Wendy Pegan, host of All About Love, relationship coach, divorce mediator, and founder of Creative Relationship Center, where our philosophy is to empower couples and families to become resilient and strong through counseling, coaching, classes, and mediation. Since everything we do involves relationships with others, Creative Relationship Center is here to assist and guide you to have even better relationships at home and at work by offering services in every area of family life, such as financial, emotional, and legal. We help couples remain court-free and stress-free. This morning I'm going to be talking about divorce through litigation, collaborative law, and mediation. And joining me today, one of my associates from Creative Relationship Center will be Christina Shine, Esquire, who is a matrimonial attorney in private practice. Good morning, Christina.
Good morning, Wendy. Thank you for having me on.
We're going to be talking about divorce today, which is not the most pleasant of subjects for people, but because it's becoming more and more common, I don't know what the statistics are of 2013, but the statistics up until about 6 years ago were 60% of first marriages end up in divorce, 75% of second marriages end up divorce, and 78% of third marriages and up end up in divorce.
I think that those statistics have probably continued. I believe I've seen something recently that is similar to what you've just described.
Which is sad.
It is
sad. And it does make me wonder, as a marriage therapist who's been doing this about 30 years now, I know that I've mentioned this to you in discussions, is that by the time couples come in, they're usually, not always, but usually in a fairly broken state. Meaning that they've reached the conclusion, one person's got their foot out the door, and they've decided that divorce is the only way out, and their ball of problems is so intertwined that it's so hard for them to figure out. But fortunately, I'm seeing more of an influx of younger people coming in, or people who have been married before and are determined they're not going to let divorce happen to them again. So they're coming in and they're doing premarital work so they can find out more about themselves, etc. But we'll save that for another show.
Okay.
Today, let's talk about the process of different ways of untangling your marriage legally. Through either litigation, collaborative law, or mediation. And you have done all three.
I've done all three, and let me just give the audience a little bit of a background on my experience and what I have done. I've been an attorney since 1988, and I think I've said this before, but when I began my career as an attorney, there was no such thing as mediation or collaborative process. So everything I did in the area of family law and matrimonial law was all litigation. And it didn't take me very long to realize how awful that is for the people who go through it.
Mm-hmm. Yeah.
So by 1996, when I learned about mediation, I went to Rochester and became trained as a mediator, and then opened my own practice. So since 1996, I've been practicing exclusively in the area of matrimonial and family law and offering mediation as one of the services in addition to litigation. Then in 2008 became trained in collaborative process and now offer that to my clients as well. So I kind of look at the three as a continuum, mediation being perhaps the softest approach to people who are separating or divorcing, and litigation being the opposite, with collaborative being in the middle.
Maybe it would be a good idea to describe to the audience what are the defining differences between litigation, collaborative, and mediation. Because I think, excuse me, most people are aware of litigation. But at least in my experience, what I'm finding is when someone feels betrayed or hurt in their relationship, that pain is a very difficult process to go through, and most people don't know what to do with it. So they turn it into anger. Anger is the motivator that gets us calling an attorney, and just, those are the feelings that make us want to sue somebody. So what generally happens is somebody feels betrayed, somebody feels hurt, and they turn it into anger. They call an attorney, and off they're running on the litigation process. And if they have someone such as yourself, you might be saying to them, let's talk about this. Maybe mediation is a better way for you to go.
Right.
But maybe we should start out with litigation and just kind of define what that is for people so that they have an awareness of the difference between the three.
Well, I'd be happy to do that, but let me just take you back a little bit. When people come to my office, for the most part, what I see is a combination of anger and fear and hurt.
Yep.
So they're looking for answers. They want me to help them fix something that's broken, and they want me to help them take the correct path for them. And a lot of them have no idea that mediation or collaborative process exists. So their first questions are always about litigation. So I do give them information about litigation, but then I also give them the information about mediation and collaborative. With regard to litigation, if somebody is coming to me as a prospective divorce client, I tell them that if they retain me as their attorney, I'm their advocate. That's one of the major distinctions between litigation and mediation, that I am their advocate and only their advocate, that I will be there to guide them, give them advice, educate them, help them make decisions, but ultimately the decisions are theirs to make because it's their lives. They're the ones that are going to be living with these decisions that they make, and I will give them my best opinion, my best advice, and as much information as I can to help them with those decisions, but they're ultimately going to be making the decisions because at the end of the day, I work for them. So number one, I'm their advocate. Number two, they have to understand that they're going to be dealing with not just my schedule, but the other attorney's schedule, the attorney that would be representing their spouse, and the court schedule. And that can be very frustrating for people because when they get to that point where they've mentally decided it's done, it's over, I need to take the steps to get this over with and move on with my life, they want to get it done, and they usually want to get it done quickly. And unfortunately, what I have to tell them is it's not going to be quick if it's in litigation.
And don't you find that, at least in my experience, is that one person is always done first? It's never done. I shouldn't say never. Occasionally, I might see the couple that is both in complete agreement. This relationship is not for them. They want to end it, and they end it civilly. But I would say the vast majority of people, one is done much sooner than the other. So while one is saying, yes, let's fine, go through the process, the other one is kind of trailing behind, still in shock that this is even happening to them, never in a million years thinking they're going to be in divorce court. So sometimes that paperwork, when the one person is ready and they're saying, why can't you just sign it? Why can't you just agree to this? The other person's hemming and hawing and just not ready to do this.
Oh, I agree completely. And as a matter of fact, those couples that I see that are on the same page and that end things civilly are most likely going to be couples that go to mediation. The people that I see in litigation are almost always people at different levels of understanding and acceptance on what's going on with their relationship. It seems to me that when somebody comes to me, by and large, they've already gone through all the emotional tumult of should they or should they not, how do they feel about this, all of the upset and hurt that they might be feeling that they've gone through in their minds. And by the time they've taken the step to call an attorney, they've worked it through, and now it's a matter of getting the business end of it done. Whereas the other spouse, by and large, is hearing it for the first time, maybe not because of a lack of having it said to them, but because they weren't paying attention or they weren't believing it or whatever the situation was, they didn't really think that this was going to happen to them. And so when they get a notice from an attorney, it's real for them. And everything that they thought that was secure in their lives falls apart. And it takes them time to come to grips with the business end, and that might sound crass, but that's what it turns out to be, the business end of dividing up joint assets, debts, and obligations if they have children together.
And the business end, I like that you said that, because I often refer to marriages as managing the marriage. It's business too. It's a business partnership, just like a partnership in any other area of life. And when you divorce, it's the same thing.
Absolutely. And as a matter of fact, what I tell my clients, my litigation clients, is that something they need to keep in mind is, regardless of who's at fault as to why the relationship broke up, and regardless of how much you think you are in the right, and that you believe that that should be somehow compensated in a court of law, a judge is not going to take a look at who had the affair, who strayed, who wasted the money, unless we're talking about wasteful dissipation of marital assets. By and large, a judge is going to look at the marriage as a financial partnership, and is going to be looking at what needs to be done to dissolve that partnership in an equitable way.
This is Wendy Pegan, and we are talking with Christina Shine, Esquire, matrimonial attorney in private practice, on the subject of divorce through litigation, collaborative law, and mediation, and we will be right back. Hi, this is Wendy Pegan, host of All About Love here on KB Radio and founder of Creative Relationship Center. If you've been thinking to yourself, he's changed, or she's not as loving as she used to be to me, or we don't have anything in common anymore, then consider making an appointment at Creative Relationship Center. At Creative Relationship Center, we have an association of professionals in the fields of counseling, legal, and financial planning. We offer couples counseling, coaching, mediation, workshops, and classes for adults at all levels of commitment, from pre-marriage through post-marriage. Creative Relationship Center can help your family stay together. Or if you've already decided to separate, we can help mediate your differences civilly without the major expense of attorneys or stress of going to court. Consider having the relationship you've always wanted. Consider Creative Relationship Center. To learn more about our couples college, couples retreats, divorce mediation, and many other services available, go to creativerelationshipcenter.com. That's creativerelationshipcenter.com.
When it comes to matrimonial and family law, you want solutions, not conflict. That's why so many Western New Yorkers turn to Christina Lana Shine, because litigation can be financially and emotionally exhausting. Options such as mediation or a collaborative process can often be the best way to work through your legal dispute. As an attorney trained in mediation, Christina Lana Shine can not only provide the mediation services, but can also convert your agreement into a legally binding contract. Let Christina Lana Shine put her 25 years of experience to work for you. Call 631-4841 for Christina Lana Shine Esquire on Main Street, Williamsville. You're listening to All About Love with Wendy Pegan. Call now, 803-1520. That's 803-1520.
Welcome back. This is Wendy from Creative Relationship, and I am talking with Christina Shine, matrimonial attorney, and we're talking about divorce through litigation, collaborative law, and mediation. Christina, you were talking about the business relationship, the idea that when the marriage dissolves, the judge is looking at it in terms of the business of marriage and the financial assets and how they are distributed, and the financial partnership that a couple has when they marry, which I think sometimes people don't necessarily truly understand. And I know people are doing it a little bit different today, but nevertheless, there are some legal ramifications for getting married and sharing some of those things. Through the divorce litigation process, what would you guess a typical litigation would cost?
That's really difficult to answer because I don't know that there is a typical litigation. I can say that a typical starting point for an average divorce litigation is probably somewhere in the range of $2,500 to $3,500 per person. And that would anticipate average assets, average income, not a lot of difficulty in dividing those up, and not a lot of difficulty in dividing up responsibilities and obligations regarding their children. Now, that would be the beginning point per client, per person. And this is another thing that I point out to people when they're considering litigation, because they have to know what the cost is. I give them not only my hourly rate, but I tell them what the probable minimal retainer will be and what they might be able to expect down the road, depending on whether the case is settled versus whether the case has to go to trial. If the case has to go to trial, really, it's difficult to anticipate how much it's going to cost, because in part, your work is determined by the reaction of the other party and the position that the other party takes. So a couple could realistically expect to spend anywhere between $5,000 and $10,000 combined on the low end, I think, as an average cost of divorce.
Okay. And I think that's probably fairly well known by most people. I think they're used to the litigation process, or at least that's been the process. That's been the way it's been for many, many years. So more people are familiar with that, and sometimes can't afford to really divorce. They can't afford to end that relationship. So somebody moves out of the house, let's say, and all kinds of problems, I would imagine, start to happen from that without making those legal endings.
They absolutely do, and I've seen that happen, and it's tragic. But by the time those people find an attorney and try to fix what they've done over the number of years that they've lived informally separated, it's virtually impossible for an attorney to go back and try to untangle everything that they've done. I've had situations where people, as you said, can't afford to get the divorce, or are just kind of stuck, maybe feeling a little paralyzed, not knowing if it's really going to end in divorce, and don't really want to take that step, not really sure what to do. So they just informally separate, and they go on their way and informally agree to pay one person, pay the other person money for instance, child support or spousal maintenance. And before they know it, a number of years have gone by. But their joint marital assets and their joint marital debts have continued to grow. And by the time they reach an attorney and ask then the attorney to divide up all the debts and all the assets, well, they want, of course, to share in the growth of the assets during that informal separation, but they don't want to share in the growth of the debts.
Correct.
During that informal separation. And it becomes very difficult then to explain to somebody how the good and the bad come together. And by the way, it's probably not very likely that a judge would give you an exact 1/2 of growth of assets during a time when you weren't really living as a couple, weren't really functioning as a married couple.
And I would imagine that's especially difficult to someone who has been married to someone who's an overspender, someone who's a gambler, let's
Absolutely.
say, someone who just wastes away the financial income. And sometimes people don't know how to stop that bleeding, so to speak, so they do run away. And in running away, of course, it just continues and ends up in the mess that you're talking about. So there goes all the assets.
Right.
So what would you say that most people, what's fought over the most in court? What's the biggest reason to go through litigation, other than the fact that at one point in time, that is exactly how people saw a divorce had to be. They believed that it had to go through the litigation process. And in a minute, we're going to talk about mediation and collaborative law as a difference and alternative to the litigation process. But what do you find people fighting over the most?
I think what I've seen is a combination of the kids and the money, and they always seem to get tied together somehow. There's always, I shouldn't say always, but very often there are strong feelings on both parts as to who would be the better custodial parent, or who should have a certain time sharing with the children. And then there seems to be sometimes an underlying concern that if one person is designated as the primary custodial parent, it's really just done in an effort to get more money out of the divorce proceeding.
So perhaps the argument isn't necessarily over the fact that I believe you have weaknesses as a parent, and that you don't make as good of a parent as I do, but holding on to some of that might be for the purpose of having that person pay more child support?
Well, sometimes it is. Don't get me wrong. Sometimes there are real legitimate questions about, is the other person responsible? Does the other person use good judgment?
And that brings up a whole level of conversation as to what's responsible.
Correct.
How you may parent responsibly is different than how I may parent responsibly.
Correct. And there's always, not always, again, there's many times there are feelings on both parts that they are the stronger, better parent, or they have the better parenting style, as opposed to their soon-to-be ex-spouse. And that is really what causes the most problems. What I find is that if people are able to come together on how they're going to parent their children once they're divorced, that typically the money falls in place.
Yeah, I would have to agree with that. I find that that is true, although when people come into a mediation, they're far less ready for a fight. Not that fighting doesn't take place, but they're far less ready for a fight, and they have at least reached the level where they recognize they are different. They recognize they had differences in the marriage, and now they realize those differences aren't going to come together or get better in the divorce. They have to learn to work with those differences in the divorce, something that they didn't learn how to do within the marriage.
That's right.
So, so let's talk about collaborative law at this point, because collaborative law is it's kind of in the middle, I see, between litigation and mediation.
And that is the way I explain it to prospective clients, that as I see collaborative law, it's kind of a morphing of the two processes, in a sense. When somebody engages an attorney for a collaborative process for either a separation or a divorce, what happens is that that person and his or her spouse have to each hire collaboratively trained attorneys to begin with. It's not something that any attorney who's not trained in collaborative process can just pick up and start to do. There's a lengthy training process in it, and it is a completely different mindset to use as an attorney than you use when you're advocating for somebody in litigation. Litigation is very positional. This is my client's position, that's your client's position. Can we somehow negotiate to provide each client with what they want or some of what they want so that they both feel like they've gained something in their positions? Collaborative is completely different. Collaborative does not talk about positional arguing or positional negotiation. It's more of a team approach. It's very much a team approach. Your attorney, his attorney are both collaboratively trained. The attorneys and the clients who go into the collaborative process sign a participation agreement. They all agree that no one is going to start any litigation while they're committed to the collaborative process. All of the same discovery, meaning all of the same financial information, is available and is requested by both parties, and the attorneys with the parties set an agenda, a schedule of what they're going to be talking about, in what order, what they're going to need to discuss those issues, what professionals they might need to bring in to help with those issues, whether they are collaboratively trained financial affiliated professionals or collaboratively trained mental health affiliated professionals. And then together that forms the team, and business meetings are scheduled. The parties meet with their attorneys privately before the meetings to prepare for the meetings, and then everybody gathers in whatever combination they decide is appropriate for that issue, and they discuss that issue and they negotiate with attorneys and clients present to resolve each issue until they've completed their checklist of issues that they need to go through in order to separate out their assets, debts, and obligations to their children.
Now, that process is more in line with the process of mediation, because we're talking about the different forms, but also the process that we go through for this. But yet that would seem that there's more people involved in this process, perhaps not in a trial. In a trial, you could be bringing in everybody.
Kinds of people, sure.
But in this process, you may bring as many as 4 or 5. Each individual has their own attorney, just the way they would in litigation.
Correct,
process.
and each attorney is still an advocate for that. It's a team approach and a team sentiment. However, each attorney is still acting as an advocate for his or her client.
So do they always bring in a affiliate for financial and mental health?
No, it's as the parties and the attorneys think is necessary.
Okay. And what about a law guardian? Because I shouldn't say most of the time, many times a law guardian is pulled in the litigation process, and you yourself have been a law guardian.
I have, and I'm serving as an attorney for children presently. That is really, in the litigation process, it's used often when parents are unable to reach their own custody and access arrangements. One party asks for an attorney for the child. The attorneys can either agree on someone who will be the child's attorney, or the judge simply picks someone from the list of attorneys on the panel. In collaborative process, I don't really see that happening. People in collaborative process come to the process with a different mindset. They're a little bit more open. Not that everybody's singing around the campfire, holding hands and singing Kumbaya.
It's still a divorce.
It's still a divorce. It's still contentious. Everybody still wants to get something that they're hoping that they'll be able to walk away with that's fair.
Sure.
But they're a little bit more open, I think, to the process of talking about the children, and that's where the mental health professionals become really important.
This is Wendy Pegan, and this is All About Love. We are talking today with Christina Shine regarding divorce, litigation, collaborative law, and mediation. You can go to our website at creativerelationshipcenter.com for a list of interesting classes and points made on today's program, or follow us on facebook.com/Creative Relationship Center. We'll be right back. Do you fight about the same things over and over? Have you thought about calling it quits? Do you need help handling a new relationship, a marriage, or just need some support getting through the stress of life without losing your marriage or your mind? Hi, it's Wendy Pegan, founder of Creative Relationship Center. Sometimes life gets out of hand, and having some support and guidance makes sense. At Creative Relationship Center, we believe that the couple is the core of every family. When we help you strengthen yourself as a couple, your children naturally make healthier choices. We offer counseling, relationship coaching, couples retreats, even classes at our new couples college. And if we can't help you stay together, we'll mediate your divorce in the privacy of our offices without expensive attorneys or court. For more information on our services, visit us at creativerelationshipcenter.com. That's creativerelationshipcenter.com. We'll keep you strong for generations to come.
When it comes to matrimonial and family law, you want solutions, not conflict. That's why so many Western New Yorkers turn to Christina Lana Shine, because litigation can be financially and emotionally exhausting. Options such as mediation or collaborative process can often be the best way to work through your legal dispute. As an attorney trained in mediation, Christina Lana Shine can not only provide the mediation services, but can also convert your agreement into a legally binding contract. Let Christina Lana Shine put her 25 years of experience to work for you. Call 631-4841 for Christina Lana Shine Esquire on Main Street, Williamsville. You're listening to All About Love with Wendy Pegan. Call now, 803-1520. That's 803-1520.
Welcome back. This is Wendy Pegan with All About Love, where we're talking today with Christina Shine about divorce, litigation, collaborative law, or mediation. What process should you use should you decide to end your marriage? Christina, you mentioned earlier, and I just wanted to bring up something that I had read in an article a while back, and you mentioned that when people are, the biggest reason that people do argue is really over children. Who
Correct.
feels that they make the better parent. And I think oftentimes when you've had a situation where somebody's cheated, or they've decided to end the marriage because they're taking their life in another direction, and that's usually because they're involved with somebody else, that the parent oftentimes who's left behind dealing with the kids in everyday life and doesn't have a new life is the one who's often the one fighting. Maybe not in all cases, but in this particular case, I'm referring to people who feel betrayed will often tend to see themselves as being the better parent. They're the more responsible one. They didn't stray outside the relationship. And so they end up using their children as a taffy pull almost throughout this process because they feel like they're more responsible. They didn't stray outside the marriage. They didn't decide to end the marriage. So by rights, they feel that they become the more responsible parent. Which, of course, one of the things that we often try to take a look at in the shared or the joint parenting situation is the benefit for the children, as well as the fact that both parents, because we were talking about opposites, both parents have something to offer these kids, where one might be more intellectually stimulating or intellectually motivating, another one might be more emotionally helpful in guiding the children. And these differences are very helpful for the kids throughout this process, because the children, of course, being an attorney, I'm going to address you being the attorney for the children, you will often see in the litigation process, I'm sure, kids who are coming to you telling you what their needs and wants are regarding their parents or how they want to be their time to be divided or split. And I'm wondering if you could just address a little bit of that, because we didn't talk about it when we were talking about the litigation process.
No, we didn't. And that really is one of my favorite things to do in litigation, is to represent children whose parents are going through divorce or separation. But what's really difficult for adults, when I'm sitting as the attorney for the child, what I see adults having a tremendously difficult time with is seeing the other person through anything but their own eyes. They just assume that their relationship with the other adult is the same as the children's relationship with the other adult. So, for instance, if you have a woman who's feeling victimized, who feels that her husband strayed, ruined the relationship, it's his fault that they're getting divorced, and now he's moving on, her hurt and how she feels betrayed by her husband, she sometimes, I've seen, projects it onto the children.
Sure.
And just assumes the children feel the same way. Mm-hmm. And when I meet with the kids, you sometimes have to sift through trying to figure out how much of what they're saying is they're protecting of the spouse, the parent who feels like they've been betrayed, how much of that is something that they've been kind of programmed by that person to say, and how much of it they're feeling themselves. Mm-hmm. Because typically what I find is kids want to be left out of their parents' problems. They really don't want to be dragged in. They don't want to take sides. They should never have to take sides.
Right.
And they just want to go on with their lives and be able to spend time with their parents and not have to even talk to a stranger, who I ultimately am, about all of these intimate, maybe embarrassments and details of their family life. And the adult parents sometimes get that, sometimes don't. They sometimes see the attorney for the child as a person to be able to leverage for their position and want the kids to go in and really be able to tell the attorney for the child what they want that attorney to hear. Mm-hmm. All the horrible things that the other person has done that should be counted against that person. Mm-hmm. Whereas the especially depending on the age of the child.
Right.
Younger kids, it's a little bit harder to talk to them, but it's also a little bit easier to get through to them because they're a little bit less affected sometimes. Mm-hmm. Teenagers, I find, are more difficult to talk to and are more affected by their parents' outbreaks, by their parents' positions, and especially if one of the parent is feeling very victimized. I find a lot of times that teenage children sometimes tend to protect that parent and don't really give me their true position on something until I've spent a lot of time with them.
How much do you think kids are affected by the whole child support issue? Because I know that often comes up with couples regarding who, unfortunately, parents oftentimes in the litigation process don't look at child support as their obligation towards their children, that if they were living in the same household, they'd both be participating, supporting these kids.
Exactly.
And when they split up, there's an assumption that the parent who's paying the child support, the parent who is left, and the one who's paying the child support is paying the other parent, not contributing that money to the children?
That's quite often a very difficult discussion when I'm sitting down with the paying parent. And it's not always the husband, it's just the higher earning spouse. When I'm sitting down with the parent who is going to be potentially the paying parent, it's difficult to explain to that person that the money paid to the other person is for the benefit of the child, but doesn't have to be exclusively segregated for that child's expenses. And that's the difficult thing for the parent to understand. They think that, a lot of people think that money should be spent only for the child's clothes, for the child's activities, for the child's sneakers, for the child's school events. Band trips, field trips, camps. But what I have to explain to them is no, under the law, anything that benefits that child is an appropriate expenditure of that money, and that includes insurance and maintenance of the house and mortgage, rent, groceries, car maintenance, anything that potentially benefits that child is a proper use of child support. And it's difficult for some people to get beyond the perspective that, well, I'm going to be paying him or her, and he or she are going to go out and buy themselves something with that money as opposed to spending it on my child.
So, unfortunately, in the litigation process, that might be fueled more by the fact that we're in an adversarial position. Now let's kind of skip over a little bit to mediation, because all of these same positions are going to be discussed, but they're going to be discussed at the mediation table instead. So whether it's the issues that are covered under divorce, let's say, the child support, the maintenance, if there is any, the division of assets, and any other issues that are covered are going to be covered in the mediation process as well. Only this process is a much more friendly process, and I know you do mediation as well, friendly process where there are not two attorneys. So there's not two advocates. There's a mediator, and everybody does it a little bit different. I do a little bit different than you do because I'm not an attorney. I'm a family therapist, but the process is to not be hiring attorneys at this point in time and seeing if the parents can just sit down and negotiate this out between the two of them.
Yes and no.
Okay.
When I have a couple come to me for mediation, I explain to them in the very beginning what the mediation process entails, what my role would be if they hire me as their mediator, and what the proper roles of attorneys in the mediation process can be if they choose to use attorneys. As I describe mediation to my prospective mediation clients, I am not I'm using my attorney skills, but I am not their attorney. When I am mediating somebody's divorce or separation, I'm acting as a neutral facilitator. I do not give advice, and I tell them in the very first meeting that they shouldn't ask me for advice because that's not my role. My role as a mediator is to act as a neutral facilitator to help them reach their own resolution of what they think is fair in the distribution of their assets, debts, and obligations to their children and to each other. Mm-hmm. I also tell them that my role, in my estimation, is to help educate them before they can make those decisions. So we always start with a discussion of what is the general understanding of the statute for the issue that we're going to be discussing. What is, in my experience, the present case law of what I see local judges doing in those issues when people can't come to an agreement? Mm-hmm. And then we brainstorm and we talk about different options, whatever works best for them. And the beauty of the mediation process is it's their agreement. Mm-hmm. And so long as they're not agreeing to something that a court would consider to be unconscionable, mm-hmm. which has to be completely out of your mind crazy that nobody would sign on to, then the court is going to respect their agreement. And they're more likely to follow their agreement because they're the ones that have crafted it.
Correct.
There is, however, a role for attorneys in the course of the mediation, and I tell them in that very first meeting that they are free to have attorneys retained if they want to. I ask them not to bring the attorneys to the mediation process, but if they want to have an attorney with whom they can connect and ask questions and go to for reassurance, that's perfectly acceptable. I do ask them, though, that they don't use that process and then degenerate it down to actually coming in and speaking for their attorneys, because that really just takes away the whole the purpose of the process. And I've only had that happen once since 1996. It was very obvious that the one party was doing it, and I had to end the mediation and send them to litigators. So there's also a role for attorneys at the end of the mediation process. When the agreement is done and we've reviewed it so that they're satisfied that it contains the terms that they wanted it to contain, I tell them that they are free to bring the agreement to an attorney to review it for them as their advocate before they sign it.
And do people always do that? Is that something they have to do? If they're in the mediation process and they both feel very comfortable with the agreement, is that something that they have to do?
I don't believe there's any obligation for them to do that. It is recommended just to protect, and as I tell my clients, it is a nice safety gap to have to protect the agreement, to protect the validity of the agreement, and to protect each of them so that they understand what they're signing, even beyond what's been discussed in the mediation, and they can have some comfort that in the future the agreement itself won't be attacked because one of the two parties comes forward to say, well, I didn't really understand because I never had anybody explain it to me as my advocate.
Well, and I'm going to address that for one moment, is that I am finding that whether it's in counseling or mediation, is that oftentimes when people are in a painful process, and they're still in a painful process, even though it's mediation, even though it's more friendly and it's not litigated, it's still a painful process for people. They often cry throughout the process because it's a death of a marriage. It's a death of an agreement that they thought they were going to be able to have for the rest of their lives. So what oftentimes happens is people are just finding a difficult time getting through this, finding a difficult time saying goodbye, and consequently their head is full. And they don't hear things that have been said. You just kind of mentally shut down sometimes, and you hear the words, but they haven't been processed into your head. So you're hearing what people are saying. You could say, yes, I understand, but just like a grief process, because this is a grief process that people are going through.
Sure.
I may not remember anything anyone said to me at the funeral. I might remember they were there, but I won't remember what they said, and yet I signed my name on the dotted line, but I really didn't know 2 years from now what the implications of that might be. So I do think there's a point at which people may certainly go to the attorneys and hear it again being stated, but when you're just seeing your life change like that, I'm not so sure that everybody really is really of sound mind that they're recognizing all of the ramifications and implications of what that will mean when they end their divorce. This is Wendy Pegan. I'm talking with Christina Shine. We will be right back with All About Love.
When it comes to matrimonial and family law, you want solutions, not conflict. That's why so many Western New Yorkers turn to Christina Lana Shine, because litigation can be financially and emotionally exhausting. Options such as mediation or collaborative process can often be the best way to work through your legal dispute. As an attorney trained in mediation, Christina Lana Shine can not only provide the mediation services, but can also convert your agreement into a legally binding contract. Let Christina Lana Shine put her 25 years of experience to work for you. Call 631-4841 for Christina Lana Shine Esquire on Main Street, Williamsville.
Hi, this is Wendy Pegan, host of All About Love here on KB Radio and founder of Creative Relationship Center. If you've been thinking to yourself, he's changed, or she's not as loving as she used to be to me, or we don't have anything in common anymore, then consider making an appointment at Creative Relationship Center. At Creative Relationship Center, we have an association of professionals in the fields of counseling, legal, and financial planning. We offer couples counseling, coaching, mediation, workshops, and classes for adults at all levels of commitment, from pre-marriage through post-marriage. Creative Relationship Center can help your family stay together. Or if you've already decided to separate, we can help mediate your differences civilly without the major expense of attorneys or stress of going to court. Consider having the relationship you've always wanted. consider Creative Relationship Center. To learn more about our couples college, couples retreats, divorce mediation, and many other services available, go to creativerelationshipcenter.com. That's creativerelationshipcenter.com.
You're listening to All About Love with Wendy Pegan. Call now 803-1520. That's 803-1520.
Hi, welcome back. This is Wendy Pegan with All About Love, and today we're talking with Christina Shine on divorce litigation, collaborative law, and mediation. And I just would like to clarify something, Christina. Earlier I had mentioned associate. Christina and I are colleagues. Just making the distinction here is that I have what are called mediation-friendly attorneys that I associate with. That does not mean that we are in association together.
Correct.
And I just
Thank you for that distinction.
and thank you for bringing that up.
Okay.
I just want to make that clarification. In my mind, someone that I associate with is a colleague. So just to clarify that Christina does not work for Creative Relationship Center, but yet is a lovely, lovely attorney that I enjoy working with on occasion. We were finishing up with the differences between litigation, collaborative law, and mediation. And quite frankly, on our break, we were talking about how we could go on and on about these differences just for long periods of time. And I think we're probably going to do another couple of shows on this because, unfortunately, today is a pre-recorded show. But I'm sure there's a lot of people out there with a number of questions that we might be able to entertain and answer some of those.
That would be wonderful. I'm sure that there are. I know that an initial mediation consultation is an hour, and that's just explaining the process to people so that they feel comfortable with it and understand the differences between the three different processes available to them.
And once again, just for our audience's information, that all three of these are processes that in how you can get divorced, how you can get legally separated or divorced. And we didn't even talk about the distinctions of those. But when a relationship ends, when a marriage ends, and a contract needs to be ended, a legal process would either be through the litigation process, the collaborative law process, or the mediation process. And those themselves, those three processes to end a relationship or end a marriage, have a process within themselves that you go through.
True.
And there's just so many distinctions in these that it's difficult for the average audience, I think, particularly when they are in pain and they worry about who's going to take care of their children, how are their children going to be affected, how are they going to live, how are they going to survive a household. A lot of times people who make decent incomes think when they're, let's say, married to someone who's an overspender, that they're going to live better when they're no longer in the same household, and that's not always the case. Sometimes people find out they may not be able to afford to live separate and apart. And as you were saying earlier, in the litigation process, it's a more expensive process.
It is.
So therefore, uncoupling is going to be more financially devastating in that process. And we've ended with the mediation process, and I wonder if we can take our last few minutes and just talk about the benefits of mediation over the other processes.
Well, let me start by picking up where you left off, where you made a statement about how people in pain sometimes don't really hear the words. They see the letters but don't really put them together. That happens for people who are in litigation as well. Mm-hmm. I've represented a number of people post-divorce who've had other attorneys, very good attorneys, represent them, but they were in such a mental scramble at the time that they finally either signed on to a matrimonial settlement agreement or went into court and heard what their stipulated agreement was, that they didn't quite understand it. And then, as you said, a year or two later, they come to me with their agreement or their divorce judgment and say, "What is this? I don't remember this. And when I explain that to them, they're not always happy with what they agreed to. I have no doubt that it was explained to them and that they were there and that they shook their head and they said yes and they said that they understood it. But because of all of the other mental upset that they were going through, they may not have understood really what they were doing. With mediation, there's a little more time. In litigation, I always find that in the end, if it's going to be settled, it's usually done in a scramble.
Yeah.
It's usually done in a conference room, in a hallway, outside of a courtroom before we're ready to get called in, and it has to be done then.
It's kind of like packing for a vacation and throwing everything in your suitcase.
That's what it sometimes turns out to be, and it's not a satisfying process for the attorney or the client. In a mediation, there's more time. There's more time to talk. There's more time to think. There's more time to reflect. There's more time for questions and answers. And it's just a more relaxed environment to make very important decisions in.
And it's not a court environment. I
It's
think
not.
that's important to distinguish. It's not a court environment, so you're not surrounded by a lot of people waiting to be called in. There's no guards with guns standing there. There's no bullpen. There's just you and the mediator. the
In
couple
a
mediator.
private conference room, correct. Right.
And usually taking place in your own office.
It always takes place in my office in one of our 2 conference rooms. It's only the 3 of us in the room talking. And sometimes when an issue becomes too emotional or becomes too difficult for people to be in the room together, I'll excuse one of the 2 and give the other party time to calm down, relax, talk to me, or just sit with their thoughts for a minute, which doesn't very often happen when you're in a courtroom setting because, again, you're on everybody else's schedule and there's too much going on to take that time.
Okay. So, would you be able to say which of your process is the favorite?
Well, I do like mediation, and I like that as a first choice, but I recognize that it's not appropriate for everybody.
And when is it not appropriate, would you say?
In my opinion, and there are different people that have different opinions, but I don't think a mediation would be appropriate if there is a relationship where there's abuse, domestic violence, if there's a complete inequity in understanding of their finances. I don't think that those are appropriate. When there's a situation where one person is a very, very strong personality and tends to want to make all the decisions, and the other person is a very meek personality and goes along with the other person, I don't think that it works when there's that kind of dynamic. But that's my approach. Other people might think differently.
Well, I think this has been a great conversation, and I certainly would like to do this again.
I would love to.
I think it would be excellent for our listening audience. And today, this has been Wendy Pegan on All About Love. Thank you all for joining us today as we discussed divorce, the divorce process through litigation, collaborative law, and mediation. Thank you to Christina Shine, who joined us today, Lancaster Medical, and Christina, who are sponsors. Our listeners for joining us, our producer Jim for helping us get through a flawless and fun show. Remember to join us on Facebook at facebook.com/Creative Relationship Center and check out our website at creativerelationshipcenter.com for information on classes for couples in all stages of relationships, articles, and polls. We look forward to hearing from you next week as we help you go from a good relationship to a great relationship. I'm Wendy Pegan. Thank you for listening to All About Love.
You've been listening to All About Love with Wendy Pegan, relationship expert, mediator, and founder of the Creative Relationship Center, and sponsored by Lancaster Medical. Be sure to tune in next Sunday morning at 11 for more of All About Love on KB Radio 1520.